Can I briefly then deal with this point that we were discussing before lunch? I was
Yes,
making
please.
submissions to about. And deal with the two scenarios that really are, I think, at the heart of the questions that your lordship have asked me. What happens in a situation where there isn't a default? What happens in the situation where there is a default?
Yeah.
Where there isn't a default, and there's, I should say, no renewal, on the 31st of March 2022, the participation matures. What that means is that the risk that Yieldpoint had assumed for a year in respect of the 5 million comes to an end, and it is entitled to be paid back its $5 million. It then, in consequence, it gives up the transferred rights that it has acquired to proceed against MTV are transferred back to Kimura. There's no need in that context for a fair market valuation mechanism, because the deal was you're on risk for a year. If the risk is not eventuated and the risk is a risk of default by MTV, you get your money back. And you've been paid handsomely for putting your money at risk for a year, but that's just the price paid for essentially the insurance that Kimura has got during the course of that year in the event that MTV defaults. The other situation is the one that we're dealing with. MTV does default during the course of the year, and that could have happened on day 1 of the year or day 364. Doesn't matter in terms of the outcome. Maybe it doesn't affect the outcome. In that situation, the risk that Yieldpoint assumed during that year has come to pass. And if the outcome were the same, irrespective of whether a default had happened, that would be a very surprising outcome, given the structure of this transaction and given what Kimura had paid Yieldpoint for taking the risk. At that point, 31st of March, the participation matures. What does that mean in the context of a default? What it means is that Yieldpoint has the right to be paid back, but not $5 million US. Whatever its investment is then worth, as at that date, in light of the default. Because if it were otherwise, it couldn't realistically be said that it was taking any risk in the preceding year, and the transaction would make no sense whatsoever. At that point, the question is, how do you work out what they're paid? And the answer is, they either agree it between themselves, or if they can't agree it, they have to go to some sort of process that involves valuation. But these are sophisticated market participants, and this is not an unusual situation. It's one where one would expect a valuation to be arrived at quickly and one gets the money back. And in the meantime, I suppose it's important to emphasize, Yieldpoint still has its transferred rights, or the rights that it has by way of security against MTV, which have a value of sorts. Why doesn't the
further, sorry to interrupt you, but there is a further variant on that, which seems to me to be perhaps more consistent with the idea that you are participating and you get back what your investment is worth.
Yes.
At the end of the year. And that is this, that default or no default, the bargain is you get back what your investment is worth at the end of the year. But it's open to the parties to decide what the market value will be, and they can notionally fix it at par in the event that there's no default.
Yes, except that's an alternative scenario. Neither my lady's scenario nor mine involves Yieldpoint getting $5 million back, come what may,
No.
in the event of default. And
What you've got is a market value, but the parties have basically said if there's no default, we'll fix the market value at par
Yes.
because you're no longer on risk.
yes, now I mean, ultimately, I suppose when one looks at the agreement, you don't find any of this, and that's the problem that the judge had with it. What I've tried to do by identifying the sort of 4 scenarios that arise at the end of the transaction, and that 3 of them don't involve the need for any valuation mechanism, is to identify that this really is it's not a rare problem in the sense that it could arise, but it's not necessarily the outcome that one would expect the parties to have anticipated when they entered into the agreement. So what one has is something that the judge puts it, I think, in the way I would suggest incorrectly in saying this is an inevitability that you're going to get to this point. It's not an inevitability in my submission, because if you get $5 million back because either the parties have agreed that that's par or because that's the deal, absent default, you don't need a fair market valuation mechanism in that situation. Or when we talk about a mechanism, all one needs really is 2 sophisticated market participants working out what the thing is worth in circumstances where it must be worth less than 5 million because the risk has eventuated.
Well, if everything goes perfectly and everyone was making lots of money, then no problem.
Of course.
But it does seem that, you know, in a situation where what are Yieldpoint's rights at maturity comes into issue is going to be where things aren't going swimmingly, whether there's a default or not.
Yes.
And one of the questions I've got is, where does one get from any of the documentation we've seen a linkage between default and maturity? And why is the risk being assumed a risk of default? I mean, that's not the limit of a participant's risk, is it?
No, it's not. And if one were in a situation where the documents were coterminous, you would have the risks would ultimately be the same between the two.
Yeah.
What one is trying to do in interpreting, I suppose, the words maturity date of the transaction is to give them meaning, giving them substantive meaning. To take the point that my Lady Justice Falk put to me before the short adjournment, that they have to mean something. And I totally agree with that. They do have to mean something. If it simply ultimately meant you get to the 31st of March and then it's essentially you just take a view on what the thing's worth in light of what's happened over the previous year, it would be difficult to reconcile that with a transaction or contract that ultimately had identified the 31st of March as being a significant date. Something happens on the 31st of March, and what happens is that the participation comes to an end.
Yeah.
What that means in substance is that the risk that has been taken on comes to an end. Now, it may be that I'm being too harsh on my client's position to say it's only a default that would make a difference to the position, but that, in a sense, is the only concept that one can really adopt that involves clarity in relation to this.
I suppose you would say that we know the participation comes to an end, but we know that the transaction is continuing, and we know that there's been no default. So the transaction continues, but Yieldpoint are no longer at risk on it. So they get their investment back.
Yeah.
And thereafter, all the risk is once again assumed by you.
Exactly.
In relation to the 22 million.
Exactly. And then the only question is, well, how do you deal with the relationship between Yieldpoint and Kimura at that point? And the answer is, in a sense, it's binary. If there's no default, you get your money back. If there is a default,
you're almost turning it into a form of default insurance.
Well, there are other elements to it, aren't there? Also, because in the period of the participation, there is a reduced exposure generally, so far as the position of Kimura is concerned. And of course, Kimura ultimately is a fund that has its underlying investors. They are their returns are keyed to the risks that Kimura is taking. It was selling down some of the risk, and
Well,
that had
the only risk you're protecting against is the risk of default.
well, at the least, that's what you're protecting against, I would say.
So what
I mean,
else are you protecting against?
I'm confining myself to default.
Yeah.
It doesn't matter for present purposes whether it went further than that. For clarity, I'm confining myself in that way.
Okay, thank you. We are going to have to start to hear from Mr. Pilbara soon.
Of course, I'm very grateful for the indulgence.
Let me make a note of that.
I should say that we invite you to allow the appeal if you agree with my submission.
Thank you very much. Yes.
My lord, I will keep an eye on the time, and my learned friend has had 2 hours 55 minutes of our joint 5 hours. So that's because he had an extra 10 minutes before lunch because we ran on. But in either way, I recognise we've got to finish this today. Equally, I recognise.
Well, we covered a lot of ground, I think, including quite a lot of. We've debated quite a few of the points. I suspect
we have.
Yeah.
We have. Anyway,
I'm
let's see how we go.
I'm not hurrying you.
I will say what I need to say. My lord, let me just tell you how I propose to deal with this. I wanted to start with a brief consideration of the judgment, just to get in mind what its stages and parts are, what it does and concludes and why. For two purposes. One, you will see, and you'll have seen it already, in my submission, it's an entirely conventional orthodox judgment. It takes quite conventional steps as it works through the analysis. And if one thinks about the criticisms of the judgment, whilst Kimura wishes the judge had reached a different conclusion, there's really very little criticism of his approach. And what little criticisms there are, the ground 2 points, are really very much small beer and can be dealt with quite quickly.
Yeah, we are dealing with a question of construction or interpretation here. So a judge can go through the entirely orthodox process, and yet this court might disagree with the outcome.
I accept that. And the second purpose to look at that structure is because the judgment throws up quite clearly and squarely, I say, what is the key question here? What is the driver? And that will allow me at the outset to tackle that.
Yeah.
So that will be my first stage. Having done that, I then do want to, as I promised to do in my skeleton, come on to working through the relevant materials in a logical, chronological order, which I say is actually a vital exercise to understand what these parties in fact agreed. And doing that will throw up actually all the individual analytical points that my learned friend has touched on at various times. And at the end, I would aim just to draw that together and respond in summary to the grounds of appeal and the specific arguments made, which I should then have covered that ground in the previous section.
Yes, thank you.
So firstly, the judgment. You'll have read it, and so I in many ways probably don't even need to do this, but you'll see it starts with an introduction to what sub-participation is in general terms. It identifies the respective positions, notes the awkward interplay and the fact that both sides are suffering linguistic casualties, sets out the background, so it tells us about the facility, it tells us about what in fact took place between these parties, making findings as they go along and actually identifying the relevant factual background, running through to a conclusion of the contract, explaining what he takes from the account and why. From para 47, then he deals briefly with the post-contractual events, just very briefly, before coming on to his analysis of the contract. For those purposes, the learned judge considers first what a sub-participation is generally. He sets out the arguments for Kimura's contention, essentially, that it's unlikely that parties would use documentation designed for and set up for a participation to conclude something that in truth is not a participation, at least in part. And that's a perfectly sensible point. That is unlikely. He identifies the difficulties. And then 68, my learned friend kept coming back to it. He identifies the first key point. Well, if it is the case that these parties did use sufficiently clear language to create a hybrid form of sub-participation, if that's what these parties did actually agree, this hybrid thing, then the contractual wording can be modified to accommodate that. So if that's what I found these parties did, it can be made to work, which throws up And he says those problems can be surmounted because the framework is itself an adaptable thing. So the question is that in fact what they agreed in this case? What was it that these parties did? What was this commercial deal these parties did?
Yeah.
And 69, he says that these differences do have to be surmounted in order to give effect to what the parties agreed for this particular deal.
Although with some discomfort.
But yes, with some discomfort, he recognises that. And 70 to 79, he explains why he reaches that conclusion, starting with and building off the fundamental disconnect between the term of the agreement between Yieldpoint and Kimura and the term of the agreement and the repayment terms of the agreement between Kimura and MTV. And that is what I identify as the key question. So I'm going to come back to that. It's what the judge really built it all on as well. And then he considers the points on either side, including on our side, obviously, the fair market value mechanism. He deals with some 2 discrete points, including commerciality, and reaches his conclusion, making clear, to an extent, that his conclusion is a least worst conclusion. Neither side's case is unproblematic, but Kimura's is far more problematic. And then he uses that phrase in his permission to appeal. He uses far more problems in the judgment, but theirs is far more problematic, and it's a yield point which makes the more sense, involving, as it does, the general framework yielding to and moulding to fit the particular transaction as it was clear and common ground that it should do. Now, as I say, all parts of that logic and flow of that are entirely conventional and orthodox. I understand your lordship's point that doesn't necessarily mean it's right. But that analysis targets, hits as the key point. Well, what did these parties in fact agree on this occasion? Is it clear from the words they used that they did in fact agree what he called a hybrid participation, one in which the parties were participating as to income and interest, so that really is only going to be paid, pay as be paid, and in this case, Yieldpoint did only get paid interest and income when it was paid, and except on the pleadings that they're only entitled to income and interest when it is in fact paid. Was it hybrid, and it was a participation in that sense, but not a participation as to capital? That points us to the key question, the key issue, and that's that I want to grapple with at the outset, and I'm going to keep coming back to it. It's the what happens at the end of this arrangement question that your lordship has identified as well as a key one.
Well, is it right to say, do you accept that if that extra line had not been placed in the annex when it became the offer and acceptance, if that extra line, maturity date of the participation, was not there, then we would have a straightforward participation of the sort that Kimura.
I don't, my lord, and I'm going. That's the bingo number one question, and I'm going to explain that right now, if I may. The key issue in this case is the disconnect between the participation and the transaction, and the judge called it a temporal disconnect, but in truth, it goes further than that. The underlying facility ran from 2019 through to 2024. Began in 2019, was restated 2020, running through to 2024. And I was going to do this later when I came on to looking at the documents, but I think it's helpful to pick it up now. If we just look at supplemental bundle 1.1, and I apologise, they're having no responsibility for it, for the labelling system, 1.1, tab 13, page 174. And you will find there, hopefully, clause 6.1 of the underlying facility agreement that has the repayment schedule in the underlying facility agreement.
Please, could you give me the reference again?
Yes. So if you've got bundle 1.1, it should be tab 13 and page 174.
Thank you.
Big numbers in the bottom right-hand corner. So this is the repayment schedule under the underlying facility. And you will see, it's all tabulated nice and easily, that first repayment of anything by way of capital is the 31st of March, and that will be sufficient to get one up to 8.33%. There are further dribble payments through to March a year later, March 2023, when one's got up to only 12.5%, so only 1/8 of the capital has been paid back. By the time one gets to March the following year, 2 years after the participation has ended, one is going to have got to 25% of the capital being repaid. At 2.5 years, it will have got to 50%, and then the final 50% comes in the last 3 months. So 33 months, 2 3/4 years after the end of the relationship between Yieldpoint and Kimura, the actual underlying capital will be paid back. So the point I was making, and just so we could see it, I thought we'd look at the actual schedule on the timetable, is that the relevant fact was that the capital repayments under that started with 8.33% on the 31st of March, running then through till the end of December. Now, the participation that was initially offered to Yieldpoint was one to start on the 23rd of March 2021 and end on the 22nd of March 2022. Now, what ultimately happened through happenstance, and we'll see it when we look at the documents, was that as a result of practical matters, it couldn't start then, and it started on the 1st of April and ended on the 31st of March. But that which was offered to them on a basis that Kimura were pleased to conclude a deal on that contract was one that would have completed completely before any capital repayment was due. As happenstance would have it, the way things lined up, an 8.33% capital repayment was due on what ended up being the final date of the participation. But as we actually know, in fact, then a forbearance was granted, so there was no capital repayment due during the period. But that's post-contractual, that last point, the forbearance. But at the date of the contract, these parties knew that repayment of participation, what's called participation, I'm going to keep using that word, couldn't be made by way of repayment under the transaction. Indeed, as originally offered, as I've stressed, there would have been no repayment at all during the period of the participation, no risk at all being run as to capital, because there's no repayment to capital in the period at all.
It's actually agreed, because what was actually agreed, through happenstance or otherwise, is that there would have been a capital repayment.
And the answer to that, my lady, is this. This relationship could not be, could never have been, a pay-as-paid model. It could not be, could never have been, a back-to-back funding model. It could not be, and could never have been, one in which participant and seller were in a pari passu position as to capital, adopting those phrases deliberately, each of them as being the phrases used by the judge in paragraph 1 of his judgment, where he describes the basic characteristics of a participation, a shared risk. Therefore, this could not be, and never was, a genuine participation as to capital.
Well, forgive me, but this all started with me asking you whether, without the line maturity date of the participation,
It did, my lord.
You would not have these arguments. Without that line, this transaction would not have ended on the 31st of March 2022.
It would, my lord, because the next line under that is number of days of transaction, 364. Now,
okay.
And we will see, and it's common ground, that transaction, and that was expressly accepted by the witness at the trial, and there's no dispute at all that that should say number of days of participation.
Yes, but sorry, if you're following the template, they've incorrectly filled in that bit of the template.
They have,
right?
my lady, and we're going to look at the template and the changes made to it
But
in detail to understand.
If you didn't have the line maturity date of the participation, you wouldn't have had the 364 days. would you?
I agree, and maybe I'm being finicky in the sense that it's not just maturity date that tells you it's coming to the end then, it's also number of days, and it's also the special conditions dealing with what's going to happen at the end. But yes, I entirely accept, my lord, maturity date is the key driver, and you have to have that because this is always understood to be a 12-month deal.
Yeah.
That's the one thing that's absolutely clear. It's 12 months. So
But the key question is, what are you agreeing to do during that 12 months? Are you just making a loan and receiving the interest and income that is the deal in consideration for lending 5 million for 12 months? I will participate in MTV's interest and income payments. That's what you say the deal is.
that is, and in that I'm taking the risk as to capital on you, that you, Kimura, might not be able to or choose to pay me back as to capital, but I am overtly participating as to income payments.
So there's absolutely nothing in this agreement which is consistent with Yieldpoint, considering that it has recourse to Kimura, is there?
My lord, I said there's equally nothing. One has to work out what it is. Sorry, I got myself caught.
An occupational hazard.
It is indeed, but one has to release oneself before one gets more caught.
Yes. Well, I think you find your chairs maybe may not be as dangerous as ours at times. But
Oh, well, then I feel very sorry for you, my lord, if your chairs are even more dangerous and flaky than our ones. I would hope that yours are more capable of being upgraded from time to time in a way that the built-in benches are.
Perhaps may be frustrating.
No, but we will. The taxpayer will look into that forthwith, I have no doubt. My lord, the point I was trying to make, and your lordship makes, you've got to work out what it is, this transaction. And I say it's clear from the outset that it can't be a participation. Not at least as participation is generally understood. Because you participate in something by putting yourself in the same position as the seller, and that involves you being paid back on a pay-as-be-paid basis. So you know that as and when the underlying borrower pays, you will get a percentage of that and you will be paid back.
Why can't you put yourself in the same position as the seller for a short period?
You can, on the basis, one then has to work out what your deal is at the end, which is the key question.
But isn't that what this all turns on? So it all turns on what happens at the end of the maturity period, doesn't it?
Absolutely does, my lord. And that's what the judge identified as the key point. And
does the difficulties which confront Kimura in that regard override all the other indications in the contractual documentation that this is a sub-participation in the sense which we usually understand it?
Indeed. And let's consider what those options are at that stage. As your lordship recognises, one is what the parties expected would happen at the end was that Kimura would pay back the 5 million. Not just some sum to be discussed, some sum to be investigated, but the 5 million of capital.
Where do you get that from?
So can I just set out what the options are, and then we are coming into the language, but I wanted to consider it first. Now, if that's the case, that is a simple and intuitive deal, a very simple mechanism. It is one that I say is consistent with maturity date. When an investment matures, you repay it.
Well, then you'd say repayment date, wouldn't you? You wouldn't say maturity. You don't talk about maturity, let alone maturity of participation, if what you're saying is repayment of a loan, do you?
No.
Well, my lord, it's very easy, and this is the point I'm going to come on to, but I'll pick it up now while it is. This was not, in the nicest possible way, a contract concluded between 3 Court of Appeal judges.
No, it's. We know that there's no lawyers involved, and you've got to make allowance.
It's a contract concluded by no lawyers, by commercial men.
But you also then, given there are no lawyers there whose job is normally to point out risks, your scenario of, well, the parties assumed it would be repaid in 12 months, doesn't necessarily follow from that, even if that was the case, that they assumed that that would be the case come what may. That's the case against you. They might have only been thinking about, or even objectively thinking about, the position where everything is rosy.
My lady, that is the case against me as of this morning. That's not the pleaded case against me. It's not the case that was run against me at trial. It is the case that was run as of this morning. An acceptance that at the end of this, there is an obligation to pay us back. And it is a question only of working out what that figure is. Now, what the case was, and what the next couple of pages of my notes were going to be, was to say, well, the case against me is what happens at the end. I've lost my place now, trying to skip ahead. 1 second. What pleaded case against me? What happens at the end? Yieldpoint is simply left with its ongoing right to a share of future capital repayments to be made by MTV as and when they are made by MTV. Now that is the case I responded to at trial.
So you see,
And I
that
say,
case was you cease to be entitled to get the income payments because you've only been doing that for a year.
Yep.
And you're still on the hook for your capital, and you get it back when everybody else does.
yes. So my 1 year, 12-month fixed-term investment is in fact a 4-year investment, and I'm only going to get my capital back at the end of 2024.
Or to sort of stand the case on its head, it's an investment with returns only for 1 year, or guaranteed returns for only 1 year.
But no return of capital.
But no return of capital.
I don't actually get my money back at the end.
No.
Now that is plainly wrong. It can't be that. And my learned friend, who has taken over this case in the Court of Appeal, at least orally accepts that's wrong. No, you were definitely going to get paid back at the end.
Something.
So, now the way I was, if I may, do these submissions is just to run it first before that concession and then run it second with it because it's changed the case. But let me just run my submissions on this point as I was going to make them, and then let me show the adjustments. So, if that's not what you're entitled to, if you're not just stuck in this and you only get your money back in 2024, then they said, well, you're entitled to the fair market value now of these future rights. And we will deal with all the problems with fair market value. I promise to take those apart slowly and carefully. It's the fun part of the case for me, so I will definitely do it. But at this stage,
So the argument against you there was you'd have to get a market value as of March 22 of the 5 million being repaid over the ensuing 2 years, if repaid at all. So you'd have to discount for early receipt and
potential
risk,
failure to
for
repay
credit
in the
risk.
future. Yes. Now, it could be the case that having a mechanism like that is consonant with a 12-month fixed term. It could be done, but you'd have to prescribe how you're going to do that valuation exercise at the time, because what we're clear on is the relationship between Yieldpoint and Kimura has to be brought to an end on the 31st of March. But as the court knows, and as I say is important, there was no such mechanism. Nothing express, nothing even on the evidence discussed. Indeed, the evidence as to the discussion was to precisely the opposite effect, namely that you're going to be paid your 5 million on the 31st of March. And I do say, if it was the intention of these parties, these commercial parties, not lawyers but businessmen, thinking, what happens at the end? If the answer was not, I get my 5 million back because the term's up, and that's what's happening here, it is entirely impossible, I say, that such a mechanism, such a fundamental, vital mechanism, would not have been provided for and discussed. I say it's not something that can simply be implied or left to be worked out. It's not something that can, as was suggested below, but doesn't seem to be suggested now, be left to a court to work out if needed on a Sudbrook basis. That's entirely antithetical
Well,
to
that's
a
no doubt
fixed
why it
term.
hasn't been pursued.
So, and I do also say, whilst recognising that this is post-contractual and accordingly a forensic point, but none the worse for it, if that was the intention of these parties, then it is inexplicable that the response to the 11th of February letter stating that there would be no extension was not, okay, now we need to activate our agreed mechanism so that our relationship can be brought to an end on the 31st of March, which it was not. The notion that there was a fair value, a market fair value mechanism first appeared in the defence. Now,
Before we go on, just one point. The parties, as you've also pointed out, went into this transaction not at the inception of the facility, but at a later point. And it was discussed earlier, it's apparent from the terms of not only of the participation agreement, but what they actually did, that they commercially agreed 5 million for whatever they got. In other words, 5 million was handed over. That's if the parties without legal advisors are not thinking about downsides as they should have done. Commercially, they've put a value on this participation on day one at 5 million. So why doesn't that apply at the end of the 12 months, at least if everything's rosy?
well, that gets me. That absolutely gets me onto the notes which are written in red, which are the ones to adjust for the case as it's now run this morning. And it takes exactly that point. So what do we have now? They recognise that they do have to pay us back something at the end, but it's unclear what the answer is. And my learned friend has tried to split that down into categories by scenarios to say, well, in different scenarios you might have different problems.
I think you can ignore the renewal scenarios. I don't think they really add anything to it.
Well, only this. The renewal provisions, the special provisions specifically negotiated and agreed, provide for 45 days notice. Why 45 days notice? That was expressly discussed between the parties because those are the redemption terms on which Yieldpoint operates. So if it's going to have to pay back its investors, it will know that. So that's why it's 45 days notice and changed to that. So if they're going to renew, they've got 45 days to give notice. If they're going to renew, there's going to need to be a fresh offer and acceptance. So conceptually, what underlies that? Conceptually, what underlies that is this will be brought to an end and we will agree a fresh deal in which we invest 5 million afresh. Now, I recognise in practical terms, you'd probably leave the 5 million sitting there, but the renewal situation, given how it is set up, which is the default is not renewing and one has to indicate one is going to renew, and if one is going to renew on fresh terms, the default inherent in that is at the end, what happens is it's coming back. So the renewal situation is still itself premised on this relationship being one that has something coming back at the end. And my learned friend then seeks to say, well, there's a distinction between the default scenario and the not default scenario. But there's two problems with that, at least. The first is the contract has no such distinction. There's no basis in the contract for drawing any such distinction.
Other than the fact that you're talking about a participation.
Indeed, but a participation inherently is something that involves pay as be paid and back-to-back lending.
And a risk.
And a risk. But there's nothing in this contract that says, okay, in this scenario, we're going to go one way, and in another scenario, we're going to go another. There's equally nothing that accommodates the point Lord Justice Phillips made, that in the real world, if one's thinking about this practically, as at that date, this investment, if one's calling it that, may have a value other than 5 million, even in the absence of a default, because it's apparent that the mine has run into difficulties. There have been no defaults yet. You know, there have been no capital repayments that were due. So the mine may be in trouble. It may have made its interest payments, but it may be blindingly obvious to all the world that this mine is running into trouble. But my learned friend has had to say, well, in that scenario, it's just 5 million, which is convenient to him because he's not dealing with that scenario. But there's no logic that explains why that is the case. If it is recognised that this has to come to an end at the end of the term, either, I say, what these parties agreed was a simple deal in which 5 million would be loaned and would be paid back, or you have to have some value to some mechanism to value it. That valuation may be easier in certain circumstances than others, but you have to. And there is nothing provided for that scenario.
And the valuation of your participation in this will vary, even on something as simple as a change in interest rates.
Indeed, change of climatic conditions in.
Well, let's just keep it simple. A change in interest rates
Yes.
will change the value of your participation interest.
It will.
If it is a participation.
And the judge noted that when he's thinking about the fair market value mechanism,
Yes.
that it puts in play a host of factors which there's no suggestion at all these parties gave any consideration to. And if you have a system in which there's got to be some fair market valuation done at the end, in which there's no mechanism for how it's going to happen, and the point the judge made is, well, how does one know that's going to bring the relationship to the end on the 31st of March? Indeed, the way my learned friend puts it now is, well, in the default scenario, two things can happen. Either Yieldpoint can sell, they can choose to sell it at a discount. But that is reversing the burden, because what's supposed to be here is it's supposed to terminate automatically. It's not up to us to sell our interest. It's supposed to come to an end, and we get to renew it if we want, but it's supposed to come to an end. So the burden on us to sell point is clearly inconsistent with what's there in writing.
Okay, I think after we restarted at 2 o'clock, it was said that Yieldpoint would have, in the default scenario, Yieldpoint would have the right to be paid whatever the investment was worth as at the 31st of March.
And that was the other alternative. It was, yeah, well, we set both up before lunch, and he may have favoured one. The other is, all right, well, there's going to have to be some fair market value at that stage. Which brings us back to it being, if that is the case, it is inexplicable that that is not dealt with. And let's just consider how that might have played out. If that's what these parties thought they were dealing with. Excuse me, I'll just jump ahead and I'll just deal with the point now. Give me 1 second and I'll be right. It's this. If one considers these parties, these commercial parties are having some exchanges over the course of about a week in which this deal is being agreed. And if one just hypothesises a conversation between those parties. So Mr. Polacek, on behalf of Yieldpoint, would say to Mr. Manielli, on behalf of Kimura, so our deal's going to end on, as initially postulated, 23rd of March, ultimately 31st of March. But let's say they're discussing the initially postulated deal. Our deal's going to end on the 23rd of March, isn't it? Mr. Nally says, yes. Okay, well, I know this is a 4-year facility. What repayments are due before 23rd of March? None. Okay, so you won't be receiving any capital back from NTV during that period, but our arrangement is a 12-month fixed term arrangement. So my capital, what's going to happen to that at the end? You'll return it to me, correct? Because that's the end of our fixed term investment. He says, well, no, he would say, if he was applying the originally pleaded case. No, at the end you just have your ongoing rights as to capital against NTV. To which Mr. Polachek would say, well, hang on. Not only is that flatly inconsistent with what you told me in our meeting, but ignore that. That's going to take place over 4 years, and our deal is a 12-month one. Don't worry. What you have, you'll also be entitled to the fair market value of your right of the investment. Okay, so Mr. Polachek, okay, that's fine. Where is that written down? Because I haven't seen it anywhere in the MPA or the participation agreement. Well, it isn't actually written down anywhere, actually. Oh, what? Isn't that rather important?
But I mean, one of the difficulties is quite obviously the parties didn't contemplate this. And I could add, if you then deduce, take from that means there's an obligation on Kimura to repay by itself in all circumstances, then you've also got to square that with Kimura apparently believing it's reducing its participation, it's reducing its stake in the underlying deal.
Retained share.
Yes, and can I come to that?
Yes.
Can I come to that?
Yeah.
Let me just finish.
Yeah.
What are these parties might be contemplating? Because this mechanism that's not written down anywhere, has not been discussed and has not been provided for, is going to determine what the value of my rights are at the end of this transaction. So, when is it going to be conducted? How long is it going to take? When, as a result, will I get my money back? Will it be on the 31st of March? By whom is it going to be conducted? You? Me? A third party? Whatever the answer to that, what obligations do each party have to cooperate, to provide information? In whose interests must the person conducting the exercise conduct it? Yours or mine? Because they're unlikely to be the same. How would fair market value be arrived at? By reference to what? Judged by whom? Who is deciding? Can I contest it? Can I make submissions to anyone? Can I challenge any decision? Now, you may say these are businessmen and they might not have thought through the details, but if the arrangement between these parties was not, as was in fact said to Mr. Polachek at the time, you're getting your 5 million back, it is inconceivable that this would not have been explored.
Well, the judge effectively says that he had contemplated whether or not in fact the parties were ad idem here.
He did.
But that both parties say, and as usually the case when money passes hands in a commercial transaction, we have to find what is the objective answer to the transaction.
We do.
And as the judge says, there are difficulties on both sides.
There are, and I'm trying to highlight the difficulties that I'd like to, and I know your lordship wants me to look at the other side of it, and we are going to do that.
No, but at the moment you're addressing what I think the judge regarded, and we also regard as the crucial question of what does it actually commercially entail to have a maturity partway through a participation agreement?
What is going to happen at the end?
What is going to happen?
Given
or what's going to happen in the middle?
What's going to happen at the end of our relationship,
Yes.
given it happens to be in the middle? Exactly. That is the fundamental question.
Yeah.
And where I will get to.
And if it is a participation agreement, how does one give effectively to the fact that you have been on risk for a year and are still on risk as at the date of maturity? How do we give effect to that when there's no mechanism to do so. That's your point, isn't it?
That's my point. And the judge's answer, which I gratefully adopt, endorse and defend, is that this was a hybrid participation.
You're
It
only
is
on
not-
risk for some and not all.
Indeed, it's not in truth a participation as to capital, because it just can't be. It's given the inherent characteristics of a participation, this can't be one. It's got to be something else as to capital.
The inherent characteristics of a loan, it might equally be said that it's not got those either, because you don't need all this stuff about the underlying agreement or anything else, and you've got none of the usual boilerplate clauses that you'd expect to see in a straightforward loan.
That's absolutely true, my lady. This is an agreement done by commercial men. My lord said earlier, if that was your view, why did you do it on the template from the MPA? Well, they'd entered into the MPA 4 days before. This was the first. They'd already done one deal.
Describe it as a participation.
And it is a participation as to interest and income.
Well, can I just pick you up on that? My understanding of participation means that you're participating in the role as lender, not participating in receiving the fruits of of being a lender, but not be. In other words, you are sharing the proceeds, but you're not participating in them. You are benefiting from them, but you're not participating in any sense.
Well, and the default structure under the MPA is one that upon payment of the participation amount, the equitable rights are passed through to you instantaneously,
Yes.
and put beyond the reach of the creditors of your counterparty. So you are directly exposed to the underlying borrower in that sense, and the obligation on Kimura in this case is clauses 7 and 8. 7 is income payments, which applies if there is no obligation to pass through, and 8 is pass through. And what we have here in relation to income payments is pass through. It's an obligation to pass through receipts. So a participation, indeed even the provisions of clause 7 as to income payments have the effect of making them pass-throughs.
So that's because it's a participation.
Exactly. So in this case, we have 5 million loaned for a period in which 5 million is not going to be repaid.
Yes.
So there cannot be any pass-through
Yes.
in respect of that, because there will be, on 23rd of March, 0, on the 31st of March, or 1st of April, £416, £500 repaid. So that can be passed through, but on any view, you're still going to have to work out what to do with the rest of it at the end.
But I think the point I was asking you is, in what sense can you say, I mean, the judge saying this is hybrid,
Yeah.
but can you really say that in the sense that we all understand participation, that this is, your client is in any sense participating? It says that is in consideration for making the loan, Kimura is obliged to pass on to you a share of the interest and income it receives under its loan facility. But I don't recognise that as in any sense being a participation.
Well, my lord, the short answer to that may be this. Below, my learned friends went to great effort to put in as many authorities and textbooks as they could find about participation. And as the judge records in his judgment, no one has found any situation in which a participation has taken place, in which the end of the underlying participation, end of the underlying transaction and the underlying participation are not coterminous.
No. So this is a novel situation.
Which is why he called this Frankenstein slip and mutant and all the other things he used in his rich and varied vocabulary. You have something that is novel. Turning to, well, what would happen in an ordinary case of participation doesn't really help one in those situations. no one can find an example.
Forgive me though, but I think the point is this, isn't it? Is that the judge's attempt to square the circle was to say, well, look, we've got all of these provisions which point to it being a participation, but what is happening to the capital here looks like a loan. But I can make sense of it being in this participation framework by saying that it's a hybrid transaction where there is a participation. There's a participation in the interest and the income. And I'm simply saying that I don't quite understand that reasoning, because it doesn't seem to me that a right to be paid some sums which are calculated according to sums which somebody has received from the borrower is in any sense a participation. It just seems to me it's a contractual right to receive a share of what the borrower from you is receiving.
Well, I think essentially we're ad idem in this sense, because that is what happens here.
You're saying that it's a loan that's limited recourse as to interest and limited the recourse as to interest, or the return is whatever is received on the underlying.
Is pay as be paid under none, and if you don't receive it.
But as is being suggested, that seems to me at least to describe a loan.
Essentially,
Something that is fundamentally a loan, with some terms about how
and I don't dissent from that.
interest is paid.
Essentially, that's what this commercial deal was. And from the looks on your faces, you're thinking, well, how do you get that? Where do you get that from? And to do that, I think I need to move on to the second part of what I wanted to do, which is to step through this in the same way that the judge did, to understand actually what happened and how this fits together.
Yes.
And I'm keeping an eye on the time. So, let's just follow the history, and we'll start the supplementary volume 1 brackets 2, tab 16. Page 432. Right at the bottom of the page, 19th of February, which is, congrats gents, hopefully the first of many trades we can do together on the 19th of February. Now, what is the 19th of February? That's the date of the master agreement and the date of the first transaction. The master agreement, you've seen. The only point I would make about the master agreement at this stage is that it is pointed out that it is the BAFT standard form, as to which I entirely accept that it is a standard form, but the uncontested evidence at trial was that my client didn't know that it was the BAFT standard form. It was never mentioned to anyone that it came from any particular source or had any particular guidance associated with it. It was just understood to be a generic form put forward. So that's the master agreement. And the first transaction, well, neither party put the details of what happened in or the documents relating to it. You know from the evidence and the judgment that it was a $3 million 90-day inventory financing of sunflower seeds. And we also know that the end date of that participation was the same as the end date of the underlying transaction. That's there in the transcript. Beyond that, we don't know. But we do know that it had a 90-day term. So 4 days later, the 23rd of February, we're still very much in the first flush of that, and that's all being worked out. So on the 23rd, in the middle of the page we have open, Mr. Polacek for Yieldpoint says, gents, we took in some more capital for March, so if you guys have any other deals in the hopper, all ears. To which the response is, you guys are on fire. So nice bit of schmoozing there. We're going to have a good relationship together. We can do more deals together. We do have a copper asset we're going to show you next week, which is a 1-year structure with profit kicker upside. We are preparing our teaser. So right from the outset, we have 1-year structure, profit kicker upside. In fact, it's the best part of a month until they come back, the 18th of March, which is a meeting by Zoom on the 18th of March. As to what happened at that meeting, the position is now clear and established as a matter of fact in the judgment, but just let me run through it so that we are clear. Mr. Manielli, in his evidence for this meeting and all the others, just confirmed
Where
that
are we now?
we're not in any document at the moment. You can, I think we're going to be, we're not quite going to be done with that bundle, so don't get rid of it just yet. We're going to go on to the next tab in a minute, but let me just tell you about something before that. So the 18th of March is the first meeting between the parties. Mr. Manielli confirmed in his evidence that there was a meeting. Mr. Polacek in his evidence gave an account of that call, and no reply evidence was served, it wasn't contested, and the judge made findings about what happened in that call. And the references to the evidence, if you wish to look at it, is paragraph 12 of Mr. Polacek's first statement, which is supplemental bundle 11749. The relevant parts of the transcript are pages 33 to 36, which is supplemental bundle 2259897 and supplemental bundle 2259 902 to 904, which is the judge grappling with the consequences of Mr. Polacek's evidence being unchallenged. But when one gets to the end of that, by reference to the judgment of Mr. Polacek's evidence, was that during the call, it was discussed the deal was a 12-month fixed-term transaction with an attractive base case return profile, as well as upside price participation, which would lead to double-digit returns. So 1-year structure, profit kicker upside, fixed term. It was clear that whilst the underlying transaction was an ongoing one, which would continue to run after the 12 months, our proposed participation was a fixed term participation. That, and this is the bit that got examined orally, during the 18th of March meeting, Mr. Polacek was told that Kimura would pay back the $5 million at the end date or at the end of our deal, or equivalent words, judgment Paris 31. And at a later virtual meeting, he was specifically told it would be on the date of 31st of March. And he was given the assurance about being paid back on the 31st of March at that later meeting. And as you'll be aware, the judge has found that as a fact. That is what took place, and that is what Yieldpoint told Kimura. That's judgment, paragraph 70. So just completing the evidence on this point, Polacek's first statement. Our deal with Kimura was essentially a fixed-term investment backed by Kimura with secondary collateral from the mine itself. This was consistent with what we had told Kimura about our approach to investments in terms of not wanting to take a principal risk on the performance of the underlying asset. And that refers back to paragraphs 9 and 4 of Mr. Polacek's evidence. So that was the virtual meeting on the 18th of March. The next was 22nd of...
When is it said that Kimura was told that Yieldpoint didn't want to take a principal risk?
At that first meeting, 18th of March. That's Mr. Polacek's account, uncontested account of the first meeting. Would it help to see the underlying witness evidence? Shall I take you to those pages?
Well, I'm very unsure at the moment about the status of all this. I mean, it seems absolutely classic parole evidence.
Well, the judge took it into consideration to identify the commercial purpose. Expressly, that's expressly what he did. He's in order to identify the commercial purpose.
The difficulty is, there's no doubt the parties were talking about it being a 12-month fixed investment, and that's fully reflected in the reference to maturity date of participation. And we've also seen the guide at tab 2. So there's no doubt that the parties were from the outset, and Kimura was offering 12 months.
Yes.
I'm not sure how it really helps us with the construction of what the words in the contract actually mean, because nobody's suggesting that these parties were considering all the various scenarios here, including default or potential default. I mean, there's no doubt, I think, no one would really dispute that what everyone was hoping here and expecting was at the end of 12 months, they'd be paid back 5 million pursuant to the maturity date specified. But the more difficult question is, what's the nature of the transaction such that if they don't get paid back?
Understood, my lord. Well, let's move on then to the next stage in this.
Yeah.
Because one thing that I think it is important to do, and the way that one does that is by tracking it through, is see the changes that are made to the template.
Yeah.
And that, I say, is not inadmissible reviewing of drafts.
Absolutely not. That seems to me to be admissible in that we're seeing how the you mean the intermediate drafts?
So the way the judge did it
Yeah.
was to do it by reference to the intermediate drafts, because he dealt with it chronologically, because I showed him the documents chronologically. And the advantage of doing that is in some of them the changes are tracked so you can see them. So in practical terms, there's an advantage to seeing them as they line up. But ultimately, the difference between the template and that which was agreed is, I say, an entirely relevant consideration in construing this contract. Because if parties work off a template and make changes to it, identifying what those changes are, which one can only do by comparing the original and the change, is fundamental to understanding what they
You
agreed.
do it by comparing the original and the change without going through all these stages in between.
I say the advantage of doing it on the way is that some of them are marked up so one can see them. But if your court are happy to have the two documents next to each other rather than marked up,
I think we're all agreed that looking at the intermediate drafts isn't really appropriate.
I'm
But
happy.
you certainly, and in fact we already have looked at the template and comparing it to what was actually agreed.
Well, we've identified one of the changes.
Yes.
There are.
No, I'm not saying we've done. I'm saying we've already embarked on the
Yes.
exercise.
Okay.
But you show us whatever you want to show us, Mr. Oh, right, yeah.
All right. Let me take it in this way.
Yeah.
Whilst we have it, we see on the 22nd of March, the very next day, tab 17, which is the bundle you still have open. If you've gone away,
Sorry, I put it away. It's tab 1 or 2.
This is the covering letter to the investment summary.
17, I think.
indeed, yes. So
So it's actually
Yeah.
volume one,
two.
volume 1 of 2. And it's then sending through the investment summary, which is the transaction overview document, as it's called in the judgment,
Yeah.
and a draft offer and acceptance document.
Okay, but so the transaction overview is the document you've seen before.
You've seen that before. And the relevant point from the offer and acceptance documents, if you have the covering letter still, attaching the draft offer and acceptance as documentation for the $5 million participation, which we would be happy to accept, value date tomorrow if that suits you. And the offer sent through, which one can see at 437,438, is one that has a start date of participation of the 23rd of March, a validity date of the 23rd of March 2022, that's at 438, and a number of days of 12 months. Now, there's obviously a few linguistic problems there.
It doesn't use the words maturity.
No, it doesn't. It refers to the validity date of the transaction as being the 23rd of March 2022, which is obviously intended to be the participation. And at that stage, it has added in two things to the template. It has added in start date of relationship, because one doesn't normally need to have a difference between the underlying relationship and the transaction. And it's added in number of days of transaction, which does not fall within the template. Again, because one does not normally have a disconnect between the participation and the transaction. And
Well, I'm quite confused parties at this point, as one could say.
indeed, but one sees from what they're adding in, they're adding in a transaction that, as your lordship, I know it has this point, which has a disconnect between 12 months, and they're having to make changes to provide for that, because that's not in the template. The template doesn't contemplate the temporal disconnect between participation and transaction. One has to add things in to allow for that. So at that stage, yes. At that stage, it's clear that we have they're trying to adapt this for a time-limited deal, a deal which involves my client receiving LIBOR plus 7.5%, which is obviously not the same as the LIBOR plus 8% that Kimura are receiving. So Kimura are taking a nice little turn on the way through. They receive LIBOR plus 8% under the facility, and they're offering us LIBOR plus 7.5%. So the notion that we're in the same shoes as them fails on that basis as well. And they're offering to accept the deal, which, if it were accepted then, which they say they're happy to do, will conclude before any capital repayments are ever going to be made. So, even at this stage, we have what is proposed, a transaction that's going to have to engage the fair market value mechanism, because there's going to be a disconnect between repayments underneath it. What can I say about, let me just grapple for a minute with the fair market value mechanism. Given that the judge stated that the fact that Kimura is driven to formulate this kind of exit regime at maturity is the most telling point against its interpretation of the MTV participation, you would have thought that the fair market value mechanism and Kimura's case as to it would feature heavily in the appellant's skeleton. But it doesn't, and indeed it was the last point they came to orally. Let's grapple with the points they actually make about it in writing and understand why they are wrong and why it does present as big a problem as the judge thought it did. So, dealing with it in writing, they did in paragraphs 18 to 20 of their skeleton, which is core bundle, tab 2, pages 32 and following. So there, you can read paragraph 18 to yourself rather than me reading it out. The court all has that. Page 32. I'm sorry, my lady, we're at the core bundle.
Yes, I know.
It's very difficult to tell them apart without a nice big clear numbering on them, I apologise.
Well, the worst thing from my perspective is that all the page numbers are wrong, but I do get there eventually. So, page 30.
Page 32 should, I hope, be paragraph
That's all right,
18.
yes, yes.
The core bundle numbering shouldn't have gone amiss.
Four's fine.
Yeah, because things were taken out of the supplemental bundle. Anyway, so The point in paragraph 18, and you've read that yourself, is to say it's not unworkable, it's conventional. But it's absolutely not conventional. As the judge held, it's entirely contrary to convention. No example being found on the authorities or any of the textbooks in which an arrangement like this is put in place. No one's found an example of a participation that did not end at the same time as the underlying transaction. And I've discussed already one that lacks the fundamental characteristics, pay as be paid back to back. So just saying, it's not unworkable, it's conventional, is no answer at all. It's not conventional. How did they explain it before? And it was 84.7 and 84.8 of their original underlying skeleton. And I could tell you what they are because we've largely got it orally from my learned friend today. But they said, first option, Kimura has to make an offer and Yieldpoint can decide whether or not to accept it. That's what should happen at the end. Second option, they have to make an offer and there's an actual obligation to purchase at fair market value, which will be determined if not agreed. That's how they explained it below, and it's largely where we've got to from my learned friend today. So that's how they explained it below. But what's wrong with that? Well, first, as a matter of fact, they never made such an offer.
That doesn't really help us in terms of interpreting the agreement.
Second, such an obligation entirely subverts the notion that this is intended to be a fixed-term arrangement, because it leads to a scenario, as the judge found, in which Yieldpoint are going to continue to be exposed. Because if actually at the end one has to settle in and work out what this is all worth, then the relationship is not being brought to the end on the 31st of March.
Well, it depends what you mean by exposure, doesn't it? If the
Sorry.
It depends what you mean by continued exposure. It depends whether the valuation, if there is a valuation, is as at 31st of March or later. There's a separate point about timing, potentially, delay in getting money, but it's not the same point.
It's not the same point, it's true. One could say, all right, this valuation has to be done as at the 31st of March, such that the fact that there has been X, Y, and Z relevant change following that date is irrelevant to trying to work out the fair market value of this thing. But if that's what one were doing, one would undoubtedly have identified that, one would have explained it, one would have made clear what this mechanism is. Equally, one could say, well, there just has to be some fair market valuation, but that is going to beg the question that my lady identifies, which is, well, how is one doing that?
Well, could you not just go into the markets and see what the price of a credit default swap would be for this debt?
The answer is, I don't know whether one could or could not, but in many sense that still begs the question, which is, one, it is now accepted, it is as of today accepted, that something is going to have to happen.
We're talking about a financial instrument here, which has pretty clear parameters. The variables are the creditworthiness of the debtor and the interest rate and the income potential. I wouldn't have thought it'd be too difficult to find a financial counterparty who would give you a value of how much they would buy your participation amount out for. And it may well be it wouldn't be straightforward, but you've got 45 days to do it, haven't you?
On the face of it, you've got 45 days to do it, because 45 days before, what has to happen? We don't need to do anything.
No, but
45
days before, you know whether or not you're going to renew.
Exactly. So they know. I mean, on 45 days before, if we wish to renew, we have to tell them we wish to renew.
Otherwise, they can assume that you're
exactly. So we don't have to do anything.
No,
they know 45 days
both
before.
Both parties know 45 days before that they've got 45 days to work out the price.
Indeed.
And they go to various banks that provide credit default swap transactions and ask how much would it cost to swap out this debt.
Yeah, and
And they'll come back and say, well, we want a premium of X.
yeah, and they ask that
See
bank.
too much.
Can I say
difficulty
this
in
then,
that.
my lord? They ask that bank on day 44, how much would you pay to swap this out?
Yeah.
The bank says 100. And so they pass it through to Yieldpoint saying, we'll give you, the bank says 100. Yieldpoint says that's ridiculous, that's far too low. So go and ask another bank on day 40, by which time that bank is valuing it differently. Because actually, the situation is not the same as it was on day 44 when the bank was looking at this, even if that bank is aiming to value it as at the 31st of
No,
March.
what you do, I don't think you would do that. I think what you would do is you would line up bank or more than one bank on the basis that they would give you a value on the 31st of March.
And then assume that is lined up,
Yeah.
and assume Kimura line up bank X, maybe banks A, B, and C.
Yes,
And Yieldpoint say,
I
you
understand
can't
that.
possibly pick
But
those
at
banks.
that point, we're getting down to a rather narrower debate, aren't we, as to
Well,
how you.
You may say we
treat
are, my lord,
these.
but it's a fundamental debate because this has got to happen by the 30th of March,
Yes.
and there is no attempt to identify the mechanism
Yes.
that would allow it to happen.
Well, I
And
think
what
one
one
thing one can
draws-
say is that although, as the judge put it, perhaps in Rolls Building's terms, this is at the more modest end of the spectrum, it doesn't seem as though these parties can agree on anything.
Well, if one tracks one way through the documents that are in the bundle,
Yeah.
and I'm not going to do it because A, I don't have time, and B,
Yeah.
this court will not allow me to do it. And you know that is the problem about
Yeah.
the points of
You say
construction.
your client is the reasonable one.
No, I'll say what you see is actually no suggestion at any stage that what has happened because of the problems in Chile is that there now needs to be the implementation of some mechanism to work out the value.
That's the. You're looking at what actually happened. It's not relevant, is it?
Your jury
The
point.
subjective positions of the parties, and it postdates the contract.
I understand that, my lady, and I
Your
was being
better
asked.
point is that as a matter of construction from the very beginning, nobody contemplated anything would happen other than that you get your 5 million back.
Well,
That's got to be your point.
But that's what I come back to. We've got to ask what are they contemplating at the beginning?
Yeah.
They're either contemplating that there's a very simple mechanism, which is you get the 5 million back, or they're contemplating there is some other mechanism which will allow us to value it at the end, but it's not 5 million, it could be up, down. And is it the case that if they were contemplating the second, is it remotely realistic that they contemplated that without making any provision for it at all? And the bull point is, I say, it's simply not realistic that commercial parties would have had that contemplation objectively between them at the time and made no provision for it, never discussed it, never touched it at all. The more natural inference from its absence is that they did just have the simple contemplation that the 5 million would be paid back at the end. And you may say that having that simple expectation is born out of optimism on one or other side, but one has to look objectively back at that stage of which is the more likely of these two interpretations, given the total absence of the mechanism that would be required to give effect to one of them. And it's that absence that leads the judge to conclude that the option
Well, I
he
think-
found is the least worst.
I think that the real issue is I think it can't be in dispute that the parties were proceeding on the basis that this was an ongoing facility. It's been going since 2019. They were looking forward to making lots of money out of it. Their interest and their income. They were all anticipating that a year later they would get back their 5 million, having received a 10% return over the year, and that no doubt was the hope and expectation. But the different question which we have to ask, it seems to me, is was the intention of the parties that your client would not, their capital would not be exposed in any way, that they would be entitled to receive these quite large returns without any capital risk? And that's the question, it seems to me, which drives the construction of these provisions, such that you go so far, and I think you say you're quite blunt about it, that this should be construed as a pure, simple loan for 12 months in consideration for you receiving the interest and income from Kimura, provided that they've received it from the borrower.
Two things on that. I say it should be construed as a hybrid participation, like the judge put it, to which you respond back to me, well, in truth, that's more like a loan, and I don't dissent from that. But I adopt the judge's reasoning as to how he portrayed it.
I understand.
But I don't dissent from the digging underneath it point. And the second point I'd pick up at this stage is inherent in your lordship's conclusion is an assessment of commerciality.
I don't think I was making any. I think I was just posing a question, really.
Okay, inherent in your question,
yeah.
Because you're referring to the large returns. You're making assumptions about commerciality, and maybe I should just deal with the commerciality points now.
Yeah, when you do that, from Kimura's point of view, it's, on one view, it's giving up a return of about 10%, replacing it with a margin of 0.5% in exchange for retaining all the capital risk. Can you?
Yes,
you need to answer
and
that.
in exchange for having $5 million to invest that it would not otherwise have.
Yes.
Okay. So
Yes, but it's also got the feature that I mentioned.
I agree with that, but one's got to balance that. From Yieldpoint's submission, what is the commerciality of this? Look at it from Yieldpoint's view first. Let's do it from both sides in both scenarios. From Yieldpoint's view, they get a concrete fixed-term investment with a solid rate of return, and potential for a better rate of return if price participation is paid. All of that being up for grabs because it's only pay as be paid, which is why they want some details about the mine to assess how likely it is all of that's going to be paid. And they get that without taking any credit risk as to principal on the underlying borrower. And it's a big deal for them at this stage. This fund is 9 months old, and this investment is about 8.5% of their entire assets under management.
Sorry, Yieldpoint's?
This is Yieldpoint.
It's a big investment for you.
Yeah. So from Yieldpoint's point of view, they're 9 months into their first year of the new fund, and this is almost 10% of the entire assets under management at the time they enter into the deal. So they get a nice secure deal, which has a prospect, they think a pretty good prospect, of some rate of return. From Kimura's point of view, they are already committed to this 4-year facility. It is already fully funded.
Yes.
So they have freed up for themselves, whilst getting a helpful £0.5% turn as well, $5 million, which they can use to invest, whilst at the same time building up a promising relationship with a new counterparty, and repeat through the documents is sort of schmoozings as to it's good to do future business with you. And the argument advanced by Kimura, why would we give away most of the upside, keeping only a 0.5% turn whilst retaining the risk? They say if we wanted to invest elsewhere, we could have just got a bank loan. And my Lord Justice Phillips said earlier, well, surely you could have got a better rate out of a bank loan. To which, of course, there are a host of answers. First is, maybe you did the deal because you wanted to pursue other deals in the market which were more profitable. And that is, indeed was, the uncontested evidence, Mr. Polacek, of what Kimura told him at the time, that they wanted to pursue other more profitable deals in the marketplace. Indeed, since then, my clients have been asking around the market, and they think they have a pretty good idea of which deals they did actually enter into, all of which have rates of return significantly in excess of 10%, funding coal transactions.
Don't worry.
I've restrained myself so far.
Well, we've restrained ourselves too.
It washes over us.
But where does it all come? Let me take it in stages. Second is, what is the answer for this? Well, they didn't think that retaining that credit risk on the mine was over a period of only a year in which no substantial capital repayments were due was any kind of risk for them to be taking. They did a deal with Yieldpoint that was too friendly, quotes, in order to build a relationship. And there's plenty of evidence of them schmoozing and talking about future deals.
Yeah.
They didn't get a bank loan because they couldn't, or couldn't do it so quickly and cheaply, couldn't do it without having knock-on effects on their balance sheet or credit profile. The ultimate answer to all of that is, it is all unknown. And it's
From the
therefore...
balance sheet point, they'd have had to put this on their balance sheet, wouldn't they?
Yes.
Yes. Fair. We don't know. I mean, the judge's ultimate point was, you can make rhetorical arguments about how this makes no commercial sense. But if you do that without putting forward any evidence needed to make them out or to test them, then they are just speculation and self-serving speculation. And my learned friend can complain about me saying, well, they could have gone off and got 20% on coal deals, but I can complain about him saying, well, we could have got a bank
I
loan.
think the way you can put it very fairly is to say that one can't assume that there wasn't a commercial reason for doing this without rather more than we have.
I was going to read the way the judge put it, actually.
Yeah.
In the absence of candid evidence and forensic interrogation as to Kimura's financial state of health and strategic aims in late March 2021, let alone communication of such matters across the line at the relevant time, there is no basis for drawing any particular inference. And maybe I should have jumped straight to that rather than offering speculation on the one hand to match their speculation. But since we had their speculation this morning, it seemed we should balance it back up. So that is the point of commerciality.
Two speculations don't make something.
Yes, I mean what they do make, but that to sit there and say, well, this doesn't make any sense, is a position one can't take because one doesn't know the circumstances as to whether it makes no sense. On its
Which
face,
paragraph of the judgment was it that you were referring to?
that's
please?
paragraph 84,
Thank you very
Yeah.
much.
Well, certainly,
core bundle 5, page
Fine.
81.
yeah, but certainly I think we can go this far, can't we? Which I think would be a difficulty for a commercial judge in the commercial court, which is we can take note of the fact that a return of 7.5% over LIBOR, not sure which LIBOR, but some LIBOR,
Yeah, US 3 to 3 month. US dollar 3 month.
plus participation in profits is a substantial return on a commercial loan of 1 year.
It is undoubtedly a reasonable return. Whether it's a substantial return in the sphere, the commodities funding sphere that these parties
Well,
operate in.
we all know the sort of what are commercial rates.
I'm
commercial
not
rates on
arguing that it's doing it better than
7.5%.
is pretty good.
7.5% over LIBOR. On any basis,
You're up to 8.5.
Yeah.
If LIBOR was about 1%, it would have been about 8.5, and then you
I'm
get
not,
the
I'm not
participation.
arguing that it is a better rate than one could have got from other
and
investments.
it would, I think all things being equal, one has to assume that there was funding available at lower rates than that.
Well, conceptually, there's funding available at lower rates than that. Whether there was funding available to that party, I don't with respect, Submit, one can make that assumption. Or funding available that could be accessed in a matter of days, like this deal was done. I mean, you know, there are perfectly sensible reasons why Kimura might have entered into the deal that we say they entered into. They line up perfectly sensible reasons to say why they wouldn't have entered into the deal we say we entered into. And ultimately, I say, as the judge put it, in the absence of any evidence that would allow you to test those, it really doesn't take you very far.
I understand.
So one does fall back on what is the effect of inserting these terms into this arrangement. And that, the one thing we have not done is compare the two versions. I'm just trying to work out whether to resist the temptation, notwithstanding the direction, not to show you the interim, to use that because it's got track change colours in it, so it's really easy to see. But the answer is I should resist that temptation, and we should get the two original documents. So, supplementary bundle. The other advantage that is they're in different bundles, those documents. But supplementary bundle 1 is the template starting at page 27. Supplementary bundle tab 3 is the final version, and one will perhaps have to take one of them out so that one can have them next to each other.
Do we just need the offer?
We just need the offer, the acceptance. The relevance of the acceptance that it is expressly by terms of the offer. Do you see what I mean? It is the offer that is accepting, but beyond that, it tells us nothing more. And your lordship and your ladyships have obviously the point in the starting wording about express terms of this offer overriding or modifying, and you have the point, as the judge did, that it's not just modifying, it's overriding. But let's line up what are the differences between them. So, type of transaction, type of participation, recourse parties are all standard form, as are transaction documents. You will see that in the final version, they've removed relevant currency and credit amount. They have added, so that we now have participation amount and participation percentage. They're standard, and that gives us the 5 million, and it tells us what percentage that is of the overall facility. Goods, exporter, importer, shipment are all standard. Though shipment in the template is from country to country, and they've gone for monthly, but there we are. We next then get an addition in of a line that doesn't exist in the template. Start date of relationship, which is driven by the fact, the temporal disconnect point, the fact that there's a disconnect between the underlying.
Sorry, the date there, is that, because I thought you told us the facility ran from 2019.
It does. This is the start date of the relationship, which is the time when Kimura first entered into a lending relationship with them. And then it's got start date of transaction.
Okay, that's all I'm getting at. It's
Yes.
the relationship with the underlying.
It is. And one gets from the transaction overview and various other places. Indeed, one gets from the press releases that one has in the bundle if one ever needs them, that they have been in a lending relationship before this specific restatement of the underlying facility, which is the 5th of November 2020, which is the next date they have.
And so the 5th of November 2020 was the last restated facility.
Exactly. And so the facility is from 2019, it's restated, and the version we have in the bundles is the restated version, but their relationship is an earlier one. Next up we have start date of participation. So when is our relationship? One sees an intended division between transaction and participation, transaction being underlying, participation being as between Kimura and Yieldpoint. that that is not flawlessly observed, but the intention is clearly there.
And that's in the original.
Yep, that's in the original.
So that potentially suggests that you might not have immediately commensurate starting dates.
It absolutely does. It doesn't suggest you would ever have not commensurate end dates, but it would mean that you might well come in later.
Well, that'd be quite common in a participation.
And I think the text of the master agreement
Yep.
recognises.
Next up would be validity date of transaction in the template. But in fact, we now have maturity date of the participation, which is the insertion of a line that's not there, and obviously the most important, 31st of March 2022. They've kept validity date of the transaction, and that's the validity of the underlying transaction, showing the disconnect between the two on its face. They have added in number of days of transaction, which should be participation, and that was not disputed at trial, and Mr. Magnelli accepted that was an error on his part when he was amending this. We then get into the payment terms, latest date for shipment, latest possible due date, and applicable rules, all of which are given as not applicable. The latest possible due date of the transaction would obviously be the 31st of December 2024. One might take from that, the fact they've not bothered to insert that they recognise that the end of the underlying transaction is irrelevant to their relationship. The settlement amounts they've identified. Funding details are then Kimura's details, because this is going to Kimura. Special conditions or comments, if any, that's there, and my learned friend showed you in the template that might be more detailed information about the transaction if necessary. But in this case, as the judge held, and as one can see in the documents, these are specific terms negotiated between the parties and amended as they're going along between the parties to reach a specific term as to what might happen at the end. Participant to advise seller of its intention to renew the participation amount 45 days prior to the maturity date of the participation. If the participant intends to renew the participation, any, or a possibly, new offer and acceptance to be agreed within 5 business days. And you have my submission on those to the effect that this shows a default situation is these things coming to an end. One has to take a positive step to renew, and my submission that a process that depends on a fair market value is unlikely to bring it to an end. It's more likely to lead to you being stuck, exposed in this process, because there is a further process that's going to require to be gone through.
I'm interested in the third bullet point. Why on earth would your client on your construction be interested in the slightest if there was somebody else involved as a genuine sub-participant?
Well, it brings to their attention changes in Kimura's situation. And as you know, throughout this relationship, they are monitoring Kimura's situation.
Without all we can take note of really is that that's without the benefit of any representations and warranties of the kind that you would expect to see in a loan agreement.
That's absolutely true. I accept that. I accept that these
which
commercial
would normally include notification obligations.
It would, and I accept that one has here not got the boilerplate one would normally find in a loan agreement.
Well, it doesn't use the word loan, nor does it use the word repayment, nor does it provide for any usual terms and conditions you'd expect to see with a loan. I mean, there's absolutely no, the only indication here of a loan is implication from the words maturity date or participation.
I accept that, my lord. That is driven by, and take the stages, and I don't shy away that that's what it's driven from. It's driven from the disconnect between the timings. That means you have to have a mechanism to bring this to an end, which they have given by way of a maturity date. Yeah. And the question is, what happens on that maturity date? what we've got to today is an acceptance of that maturity date means we're going to be paid something.
Well, maturity date, as I understand the term, refers to your investment maturing. That means that whatever you are entitled to be paid in relation to your investment, whether it's gone up or down, and returns are not guaranteed, that on that date you will be paid what is due on the maturity. It's very, very far from referring to repayment of a fixed loan.
I can only push it as far as it goes on its language. It says maturity date, which is what drives a judge to work out, well, what is it that is payable at maturity? Because something is happening at maturity. It's now accepted that that is repayment of some kind. What is it? And one's left there with the divide we had before between simple, clear solution.
I think it's accepted that there should be payment of some kind, but I'm not sure it's necessarily accepted it would be a repayment, because I think the participation argument is that your clients have a participation in this loan, and at the end of its investment period, it is entitled to be bought out, effectively paid out the value of its investment. And that's not a repayment of its investment, it's the amount due on the maturing of that investment after a year.
Well, my lord, and if one follows through that analysis, then that leads to a conclusion that there must be some mechanism to work out what that is.
Yeah.
And one is left then with the two options. Did the parties agree that it is simply 5 million? Or did the parties agree that there would be some way of working it out in circumstances where the party made no provision at all for any working out, such that, as the judge concluded, the least worst conclusion is that it was the simple one.
There are probably a number of ways we can restate the central issue, aren't there? And it really comes down to that contrast, doesn't it?
It does.
Yeah.
It does.
Do we regard this as, in some way, a paying out of the investment by some mechanism, or is it the repayment of the loan? It has to be one or the other.
It has to be. And the flaws in the mechanism or the case as to how one calculates what it is if it's something to be valued are, in our respectful submission, sufficiently glaring as to make this the least worst. And if one translates that into what that means as a matter of construction, they're sufficiently glaring that it can't be the objective interpretation of the mutual intention of these parties to be adopting that scheme. Because it is a point that it is inevitable was going to come up, and there is no provision for it.
Well, it was inevitable it was going to come up if there was a default.
It's only inevitable it's going to come up if there's default, in light of the acceptance now made today that in the absence of a default, we're going to pay you the 5 million back.
But that wasn't the case you faced below.
But what's the logic of that? The logic of that is, I would respect to say, a tactical decision now to try and pinhole me into a corner, rather than accepting that there is a basic distinction between a simple pay 5 million back or work out a value back. Working out a value, they might be able to say in practice, in one scenario, would be easy, but they don't have any logical basis for saying.
Or it could be predetermined. It could be that the parties agree that in the event there's no default, they will treat the value as being 5 million.
But that equally is not provided for, and one comes back to trying to work out what is the more natural of those two, given the absence.
That's really what it is. It's where it comes down. It's not easy.
Well, however this transaction works, at the end of the first year, your client will have received the income for 1 year, but the capital will only be repaid, only 8% of the capital will be repaid. So it seems to me that the value of that stake, the 5 million, is almost certainly going to go down on the face of it.
If one recognises that it is, as to capital, a participation, at least in part, so we should get that $416,500, which is the 8.33% of, assuming that is paid in. But if one recognises that as to capital, there isn't any participation, then that money is simply, if it comes in on the 31st of March, going to Kimura, and Kimura have to pay us 5 million, and Kimura are sitting there collecting in the remainder of the money over the next 33 months.
Well, I think my point was that the 5 million participation, as of that date, anyone who took over that 5 million would have to pay. Well, when they buy that slice of participation, they would not be getting the years of interest and income that you've received. So it seems to me that it would no longer be worth 5 million.
Well, I think that if you say I've sub-participated the whole amount, then it is what it's worth at the 31st of March with its going forward income as well as capital.
Yeah.
If the appellant's case is right.
Yeah.
So it could be 5 million.
It could be. Absolutely, it could be.
It could be, and obviously one understands the judge's conclusion, and the one for which I contend, is not that it's an amount to be valued which might be 5 million, but it is 5 million.
Anyway, very helpful.
Let me.
You didn't mention the retention share.
That's right. We got distracted off the document. Yes, so we have the income payments with the different rates, the rate being retained, being provided to Yieldpoint being less than the rate retained by Kimura. The retention share, which ought to be a percentage, but is instead a fixed number. I recognise, as the judge did, that is at the more problematic end of the difficulties for me. I do say it makes sense to identify a retention share when this is, as the judge said it was, a hybrid participation, such that it is prescribing the amount, retention share run together with participation percentage, of what percentage of the income payments, so that's both interest and and the uplift on the sale of copper, it prescribes what percentage of that entitlement I'm going to get.
It is odd that the fact that it's prescribed as a number rather than a percentage. You might have a slightly easier time if it was prescribed as a percentage.
I might, and it's obviously intended in the template to be a percentage, but there are a number of ways in which these documents, as completed by businessmen at the time, don't quite line up, either internally or with the template.
And line up with bullet point 3.
Sorry, my lady.
It does line up though with bullet point 3, which has been bugging me.
Well, it would line up with bullet point 3, even if that were given as a percentage. My lady led Justice Falk's point about it being a number doesn't, I don't think, affect that. One is left with the balancing exercise that the judge faced, which is I have two imperfect solutions, and I have concluded that the one is less imperfect than the other, having regard specifically to the additions into this, which is obviously most importantly maturity date, the surrounding facts known to the parties, which is the temporal disconnect and how this can't actually be a proper participation, and the full factual matrix as to what these parties intended. And we have come down to focusing on this, the key point, but let me say this, that if the court is with me and finds in the same way the judge did, that what these parties in fact agreed here was essentially a loan as to capital and that the 5 million would be repaid back, then I adopt the judge's reasoning as to how that can be made to square with the master participation agreement. And if one thinks through the stages of that, I accept step one, the fact that the parties entered into a master participation agreement that contemplated entering into participations makes it inherently unlikely that they entered into something underneath it that wasn't a participation. But if that is in fact what they did, as the judge found it was, that can be squared with the master participation agreement, because the structure of the master participation agreement is one where the offer and acceptance, the individual specific transaction, is the dominant force, and the terms from the master agreement are incorporated, save where they're inconsistent, and if they're inconsistent, they are either modified, the making of necessary changes, or overridden, simply struck out, simply found not to be there.
Most of them, therefore, are totally inapplicable.
So most of them, on my analysis, are applicable only to part of what we were doing, income payments and interest, which is the judge's conclusion. It does work together. It applies only to part and not to much of the whole, because that is the deal the parties in fact did. We've identified the hub of it, and we've probably gone over that hub. As my Lord Justice Phillips says, there's probably only so many times we can restate the essential question, and I can tell you what I say the answer to it is. So let me then come to this part, and as this was going to be stage 3 of my submissions, where I said I would, in light of everything we've said before, give the answers discreetly to the individual grounds of appeal and the responses back to the individual grounds of appeal. And one has their grounds of appeal if one wants it in tab 1 of the core bundle, starting at page 14. So they say the MTV participation did not contain the clear and strong language which the judge held correctly was required to justify a fundamental departure, to which my answer, same as the judge's, is that it did contain that clear language. The parties agreed in the final offer, the terms of which override or modify any conflicting or inconsistent terms in the master agreement, to a 364-day transaction with a maturity date of 31st of March 2022. That maturity date itself, as the judge observes, a concept that is alien to a participation, together with the term of the transaction and the special conditions and the mechanism or the regime put in place in the special conditions, understood against the relevant factual matrix as identified and explained by the judge, demonstrate that the parties did intend to depart from the structure of a sub-participation, and the Yieldpoint did not assume a capital default risk other than that of Kimura. Ground 2 is that it did not simply override or modify, but render otiose. That's an unfair characterisation of the judge's conclusion. They agreed a deal which was in part a participation to which the contractual scheme applied, and in part was not. But as you'll recall from the beginning of my submissions, I say could never have been a participation, because it simply lacked the basic characteristics of one. In circumstances in which the parties agreed that the contractual scheme would mould to an individual transaction through modification and, if necessary, overriding. The third point is the judge was wrong to reject as unworkable Kimura's proposed exit mechanism. He was not wrong to do so. The exit mechanism is unworkable. It is now, even now, in the skeleton, and really, orally, not explained how this exit mechanism works. The court has explored some various possibilities as to how it might work and brought to bear the experience of 3 experienced Lord Justices of Appeal to fill in the gaps as to how it might work. And that's impressive in a lot of ways, but also not an answer to the question. The answer is, what did they agree? And they didn't agree anything to fill this gap. They suggest it makes no commercial sense. I say it does make commercial sense, but putting it at its lowest, the judge was not wrong to say that it is not possible to conclude that it makes no commercial sense. I appreciate there's a lot of no's in that sentence, but
You took us to the paragraph.
I took us to the paragraph and I say, you can't say he's wrong to say that it's not possible to say. The ground 2 points, what I described at the beginning as small beer, none of these points, if right, would be sufficient in themselves to affect the outcome. But in any event, they are wrong. So the points are impermissible reliance on pre-contractual assurances, contrary to an entire agreement clause, impermissible reliance on negotiations and drafts, such evidence being inadmissible under the exclusionary rule, and impermissible reliance on subjective intentions. All of that can be dealt with pretty quickly, and we do it in the last couple of pages of our skeleton. So the first is what the judge relied on. I say he engaged in an entirely orthodox exercise in construing this contract. He made factual findings as to what happened, and there is and can be no challenge to those factual findings. And he construed the contract against that factual matrix, putting it, as he put it, he ascertained the parties' common objective intentions in the light of uncontroversial or incontrovertible factual matrix concerning the essence of the transaction. That's how he described what he was doing. It's taken from his permission to appeal ruling, but it does describe exactly what he was doing. Core Bundle 684 if you want to see his permission to appeal ruling. The court is entitled to have regard to such evidence in order to identify the purpose or aim of the transaction, and in turn, to construe the contractual language in accordance with that purpose. There's nothing controversial about that. It's well-established law. We have that. We have in the bundle, we have Brennan Simmons, and then we have Merthyr South Wales Limited and Merthyr Tydfil County Borough Council, which is a more recent 2019 Court of Appeal case in which Lord Justice Leggett, as he then was, restated and summarised the principles. We have those both in the bundles, but I don't think I need to tell you the principles of Brennan Simmons, that it is perfectly permissible to consider pre-contractual matters to identify the genesis and aim of the transaction, which is the phrase of Justice Cardozo, the US Justice Cardozo, which is referred to by Lord Wilberforce, the commercial or business object of the transaction, which Wilberforce himself uses, aim or object or commercial purpose, and Lord Wilberforce puts it in another way, in another case, and core commercial proposition, which is the phrase the judge himself used in paragraph 37C.
I do have some difficulty with this. I can see that you can get as far as saying the aim was a one-year deal.
Yes.
How much further you get in this scenario where, frankly, this situation appears not to have been contemplated, I find difficult with that.
I accept that, my lady. I think it's that the core commercial purpose that the judge identifies is precisely that this is a time-limited one-year transaction. And
But
it's,
that much we think is apparent from the. It's exactly apparent from the document.
Yeah.
yes, I mean and the documents from which he is taking that are the transaction overview, the way it is described the first time it's sent out. There are a very limited number of documents.
You don't need to go to the parties' negotiations to get there, that's the point.
No, well, the way this point was put against me first time round is you can't read the transaction overview because that's a pre-contractual document,
But we're past
and we've moved on from that, and it's now said that he is taking this into account to do more than identify that core commercial proposition. And I say, on the face of his judgment, he isn't. That is the proposition that he takes from it, and that is perfectly permissible. And your ladyship may say, well, does that get you far enough? That's the debate we've been having to date, but just trying to answer the ground of appeal put against me, saying he's done something impermissible.
understand what you're saying.
He hasn't. The additional point there is that it's relevant that there was an entire agreement clause, and that means that one can't have regard to pre-contractual negotiations. It entirely ignores the distinction between evidence being admitted to add another term to the contract, impermissible, evidence being admitted as part of the factual matrix to aid in the interpretation of a written document, entirely permissible. We have the decision of Mrs. Justice O'Farrell in the Buckinghamshire Council case in tab 11, but that's not.
I think the concern was moreover the admissibility of statements to the effect you'll get your money back in 12 months.
To which, if one reads the judgment fairly,
He didn't hang anything on that.
no, he observes that the conclusion he's reached turns out to be consonant with what he found happened. And when I took the point right at the beginning, I set out my views as to what leads to the conclusion, and observed that also happens to be consonant with what was in fact said. But to say that the judge has taken the one to reach the conclusion is putting it the wrong way round.
Well, is that right? I wonder, paragraph 69 and 70.
Yes.
The judge is saying that the numerous points arising from the MPA are surmountable, but were they or must they be? And then he says he's satisfied they were and had to be in order to give effect to what the parties agreed for this particular deal. Now, if he's referring to the agreement as in the documentation, then it seems a bit circular, but he seems to be, by that, referring to what they agreed outside the documentation. Because he then goes on in 70 to say, this was always proposed as a fixed-term deal. It was agreed to be renewable by Yieldpoint to reduce the notice period 90 to 45.
Yeah.
Yieldpoint stipulated for, etc. Kimura would pay us back on the 31st of March. And then 71, Yieldpoint was assured it would get its capital back after 1 year. I read those paragraphs as saying that the reason that they had to be surmounted is because of what the parties had pre-agreed.
Well, I don't think, with respect, my lord, that's the
What
right.
is he referring to then?
The right reading of it.
Yeah.
I say what he is doing, taking it in stages, is if you see what he's set himself up to, it is this can be surmounted, as in the problem of lining up the offer and acceptance with a master participation agreement and making them work together, can be surmounted if one concludes that the offer and acceptance is one that requires you to do so. And he concludes that the offer and acceptance is one that requires you to do so. And that's why, for example, in 70, he is looking at the special conditions.
Well, no, he's not, though, is he? He's referring to what it was always proposed as, and then to the negotiation of the special conditions to meet its need for certainty of redemption at maturity.
Yeah, he makes reference to the rationale that was given to him for those special conditions,
Yeah.
but ultimately it's hung on the special conditions.
Yeah. And then he says, in this immediate context, which is the parole evidence, in this immediate context, the inclusion of a maturity date in the second offer and final offer, together with special, is sufficiently strong and clear. I think I have to say, I read it as he's putting a lot of weight on the pre-contract material here. A lot of weight.
Well, my lord, obviously it's one can read it in different ways.
And you say he's not.
I say he's not doing anything impermissible. He is. The immediate context, obviously, is his discussion of the factual matrix that has taken place over the preceding paragraphs.
Yeah.
And what he's looking at is, one says, well, he's referring to the inclusion of a maturity date. That's somehow talking about what the parties did between them. But in truth, he has to look about the inclusion of a maturity date, because that is a term that has been inserted into a standard template that wasn't there before. And that is a perfectly rational way to assess these documents and the back and forth, because the back and forth has the purpose of identifying the bits that have been added in and the changes that have been made. I can't pretend, my lord, that he doesn't make reference to the fact that the evidence before him as to factual conversations is consonant with the conclusion he reached. I'm
Like the way in which he puts it. I mean, I can well understand a judge saying, in reaching these conclusions on construction, I have completely put out of my mind everything that I found about what was said, but I'm fortified in my conclusion by going back and seeing that it's entirely consistent. That's not quite how he's put it.
well, my lady,
It may not matter.
the judge has put it as he's put it. My submission is that he's engaged in, as he says he has. When he says in terms, I have engaged in an exercise of working out objectively what the intention of these parties is from the relevant documents viewed against the relevant factual matrix. I mean, it's how he has described what he's done and how he's described why he's looked at the iterations of the document and the changes, because they do, paragraph 37, evidence or encapsulate the core commercial proposition. The way he's described what he's done, I say, is perfectly orthodox. The final point on the grounds 2 was as to subjective intentions and expectation, to which the short answer is, in his operative reasoning, there is no reference to anyone's subjective intentions. In his postscript, he has a passing reference in paragraph 88 to thinking that maybe the party's subjective intentions didn't match up, but that's got nothing to do with his actual reasoning. There's nowhere in his reasoning that one can suggest he is, even suggest he is, taking into account one party's subjective intention. So, my lord, my ladies, as you know, I ask you to dismiss this appeal. We have, I think, boiled down what the core point is, as it now stands, as against the case for Kimura, as it put on appeal. And that is coming down to working out which of two possible interpretations is the more natural in circumstances in which it is the least awkward, to perhaps use the judge's word.
The least unnatural.
The least unnatural, the least awkward, involves the least violence to the language viewed against its relevant factual matrix. In circumstances which, yes, parties employed a template under a relationship that looks like a participation, as intended to be a participation, entered into a deal, the inherent characteristics of which can't be a participation because they simply don't line up and have the necessary characteristics of pay as be paid, back-to-back, pari passu. So they used a template, did something that couldn't fit within that, and one has to join then together, what did that mean? And specifically, what was the intention at the end? Was it the simple one of simply, it is to pay back the 5 million? Or is it something more complicated for which no provision is made, for which there's no terms, there's no discussion, there's no even hint of a discussion? Was it that? For those reasons, my lords and my ladies, I ask you to dismiss the appeal and uphold the judge's orthodox, sensible, and we say correct conclusion.
Thank you very much. Just give me a moment.
They only start filing into the memorial service at 5 o'clock, so it's fine.
Thank you, Mr. Bent.
I won't be very long in reply, but just a few points briefly in reply. At the outset of my learned friend's submissions, my Lord Justice Phillips asked my learned friend if the words maturity date of the participation didn't appear in the offer and acceptance, this would just be a conventional participation, would it? And my learned friend didn't accept that initially, but then eventually did accept that ultimately his case turns on the meaning of those words, which must be right. Ultimately, the point that the judge makes, that the maturity date is alien to a participation, is the point that he makes in paragraph 72, is only right if it means it's a loan. There's no difficulty in giving meaning to the words maturity date of a participation if it's not a loan. And that is the right interpretation.
Well, you could certainly say with some force that that this is an entirely orthodox use of the appendix, save for those words.
Yes.
And those words refer to the participation. So you're getting the words maturity date to do an awful lot of work.
Exactly. And ultimately, participation must mean participation in the loan, if it's to mean anything at all, not just in the fruits of the loan. It's also undoubtedly right that from what one can see, that there's no evidence that the parties contemplated the default situation in advance, in the sense that there isn't any provision for it expressly. I have to accept that. The difficulty, though, for my learned friend's case, is that if you look at what was said back and forth between the parties, the language of pay you back and a fixed term deal, they don't give you the answer ultimately in relation to the core question. It is unsurprising, if it's right that the parties thought that everything would go swimmingly and didn't really turn their minds to the question of default, it's not that surprising that you don't have a mechanism in the agreement itself to deal with it. And my learned friend ultimately didn't have an answer really to the point that my Lord Justice Phillips put to him, that participation must mean participation in the loan if it's to mean anything at all. In relation to the pre-contractual material, my learned friend started out with the memorable phrase, let's follow the history. That's the wrong approach in my submission, respectfully. The back and forth is inadmissible. What changes were made along the way to the wording in the agreement ultimately is either inadmissible or really doesn't tell you anything about what the parties ultimately agreed. There is, I think it must be accepted, nothing in the documents that were agreed that suggested that this was to be income only, or, save for the words maturity date of the participation, that it was repayable on the 31st of March, come what may.
Well, nobody's arguing rectification here. No. And the parties at the end of the day have produced a very formal documentation with some very specific words, mainly derived from a pre-existing umbrella agreement.
Absolutely. And
to construe those words on the basis of things which pass between them informally in advance, apart from being probably impermissible, is very dangerous.
Exactly. Respectfully agree. Ultimately, in relation to the back and forth, I don't shy away from the submission I made in opening that this is really the mistake the judge made. And my Lord Justice Phillips identified the paragraphs that I would rely on, also paragraph 69, 72, where you see the pivot in the judgment arising because it doesn't reflect, our case doesn't reflect what the parties had agreed, but there isn't anything as to what the parties had agreed other than the pre-contractual material, which is inadmissible.
What do you make of the point that there couldn't be any participation in capital in any meaningful sense if the underlying transaction was providing for small amounts of capital to come in dribs and drabs, and on any view only 8% coming in on the 31st of March?
Well, it doesn't answer the question in my submission. Ultimately, the question is there a sharing of risk? And is there a selling down of risk by the seller to the participant? And I suppose aligned to that, is it sensible to divide the risk into capital and income? Ultimately, if the position is that it's everything, then it is meaningful to participate in the capital risk if there's a default during the year.
Yes.
And that's the answer to it, I think, I would suggest.
You're sharing in both the risk and the reward.
Absolutely. And that was ultimately the proposition that was being offered in that transaction overview.
Well, it reduces Kimura's exposure by £5 million. That's the point.
Yeah, £5 million out, $5 million. Exactly.
Dollars, that means, sorry.
Yeah.
Absolutely. I mean, that's simply what it was. And the judge refers in the judgment to, the fact that that was exactly what was said. It's not admissible, but I suppose I mention it because if one's going to look at that, the back and forth, you've got to look at all of it. And that's the danger in looking at bits of it, fundamentally. Now, my learned friend emphasized how novel this all was because of the coterminous or non-coterminous point between the participation agreement and the participated transaction, but he didn't address the fact that, as I showed you in opening, there is provision in the MPA in two places for circumstances in which the participation agreement might end before the participated transaction, clauses 7.1, page 16, and clause 13.2, page 19. And in emphasizing that point to you today, he was, in a sense, or was effectively adopting the same point that the judge made in his judgment, that there was some significance in the fact that the MPA did not contemplate anything other than a coterminous arrangement. I think I gave you the references before, but to make sure you've got all of them, it's paragraphs 22, 58, and 72 to 73 of the judgment, where the judge referred to that point 3 times, and at paragraph 73 made very clear that he considered it to be of real significance to his analysis. But in my submission, it's simply wrong. As for commerciality, of course, one has either side's, what was in it for either side. I make no comment about the sort of points about building a relationship and those sort of things, because in a sense, none of those points seem to me to get one anywhere close to dealing with the core point, which was that this was a screaming deal for Yieldpoint if all it was doing was advancing $5 million for a year and then getting the money back. That is undoubtedly a point that the court can take into account in terms of assessing which is the more plausible interpretation under the principles that are well known as to the relevance of commerciality and interpretation. If one goes back to the transaction overview behind tab 2, one finds no trace of the opportunity being offered as a loan. It is plainly a pari passu investment in the classical participation.
Well, it's also, I think one can say that it is generally, regardless of the interest, leave that to one side, it is generally not commercially acceptable to be participating in profits without being participating in any risk.
Yes,
it's unusual that a party can have an open-ended right to the profits without risking its money.
If anything were novel in this case, that would be it. I know a friend says it's very novel.
It might be said, contrary to that they are taking some credit risk on Kimura.
Yes, but then one comes back to look at the MPA and the representation point, that ultimately it's focused on MTV credit risk. Again, perhaps this is a provision that one just crosses out, but it just adds to the pile of points that one would have to circumnavigate in order to get home on my learned friend's interpretation. As for the differences between what the offer looked like when it was first put forward and what it looked like on the 30th of March, I really suggest to my lord and my ladies that really has no relevance or importance in the analysis at all. other than that my learned friend characterised at various points in the table as he skipped through it, that these were just standard provisions, but they're standard provisions that are defined terms in the MPA that are expressly adopted without demurrer in the offer, and therefore it's helpful to me that they're standard provisions, not to him. There's nothing in my submission in the change from validity date of the transaction to maturity date of the participation that makes any difference to the analysis in the scheme of things. It's just that I would suggest maturity date of the participation is probably a more accurate characterization of the end point in the participation, but it entirely begs the question as to what that means in terms of repayment as a loan or risk coming to an end. As to the special conditions, respectfully adopt the point made in relation to the third bullet point. It isn't just the fact that one has the language of retention share there, but why would Yieldpoint care about that? Yeah, but this is it's inadmissible. But one sees that these are conditions that they specifically requested in the back and forth. And of course, in relation to retention share and participation percentage, participation amount, those points are, as I said in opening, impossible really to interpret in any other way than there being a selling down of capital risk to Yieldpoint. Can I just check and see if there are points that I ought to make that I've missed? I don't think there are. Unless there's anything I can assist further with, that's all I wanted to say in reply.
Thanks.
Thank you very much.
I'm very grateful.
Well, thank you to all counsel and to those behind them for very interesting and well-argued appeal. We will, won't surprise you know, reserve our judgments. They will be provided first in draft in the usual way for you to provide us with any typo, logical corrections or obvious errors. Not a chance to re-argue the appeal. If you would then please try and agree an order following from the judgment. If there's anything you can't agree on, then please make submissions in writing and we will determine them on paper. And please treat the draft as confidential and embargoed as per the rubric. You now know the serious consequences of not doing so. And then we will hand down the judgment electronically in the usual way.
Thank you, my lord.
So thank you all very much, and that concludes the appeal.
All right.